Good morning, everyone. I appreciate the opportunity to be a part of the Washington State Department. I think the information shared has been really good so far, and hopefully the perspectives I have to share from the industry's point of view will kind of correspond and amplify on a number of the issues that have already been previously discussed during the meeting so far. Here are the list of conversation topics that I want to address during my presentation. First of all, I want to share some FSMA inspection experiences. And these are those experiences that have been shared with me from our industry members that pertain to specific issues or topics that have come up during inspections and that I think would be valuable to share so that individuals participating in this webinar can think about ahead of time and potentially be better prepared to respond to if they do experience an inspection. Second, I want to share some ideas on how to prepare for and react to FDA inspections. Under the new FSMA environment, more firms are being inspected than ever before. And so I frequently get questions about how the inspection process works and what can I as an animal food facility, do to be prepared to respond to the inspection. So I want to share some hopefully practical ideas about that topic. And then finally, just touch briefly on some compliance assistant materials. The Food Safety Preventive Controls Alliance has already been previously mentioned, but I want to talk a little bit more about the materials and the training that's available through that venue. So first of all, I just wanted to reinforce that FSMA is multifaceted. And although the focus of this animal food training is primarily on the Part 507 CGMP and preventive control requirements that have been established for animal food, there are other FSMA-related rules that animal food facilities may need to be aware of and that may apply to them. The other rules that I have listed on this slide include the Foreign Supplier Verification Program rule, which would apply if you are an importer of foreign foods into the United States intended for domestic consumption. Another rule would be the accredited third-party certification rule. Often I'm asked about FSMA and whether FSMA requires written food safety plans to somehow be certified by third-party entities to demonstrate compliance. The short answer to that question is no, that's not what FSMA requires. And this accredited third-party certification rule only applies to importation of certain foreign foods. And that's the only instance where that could maybe have utility to an animal food facility. And then the last rule I've listed on this slide is the Sanitary Transportation of Human and Animal Food rule. There's already been some discussion about that during the meeting. I would want to emphasize to participants on this call that this rule likely does apply to your operations. If you are involved in shipping, carrying, or receiving animal food by truck or by rail, this rule likely applies to you and you need to be aware of your compliance obligations. As was shared in the previous presentation, compliance dates for all of these rules have come and gone. And so there is an expectation that firms understand what type of regulatory obligations that they need to comply with and that they are in compliance at this point. So let me switch over to my first topic and just try to bring up a few issues and different topics that have been experienced during FSMA-related inspections to try to help people think through what might happen and how to be better prepared to respond. The first point I want to make is be prepared to have different inspection experiences. If you do have the opportunity to experience more than one FSMA-related inspection, don't expect that all those inspections are going to go exactly the same way. I know that FDA CVM has done an incredible amount of training for their inspectors to ensure that investigators understand the requirements and that there's a degree of uniformity when inspections do occur. But based on the industry feedback that I receive, just because that level of inspector training has occurred, don't expect that every inspection is going to go the same way. When an investigator arrives at a facility one time, there may be a focus on certain areas. The next time, the focus may be shifted. I think the key takeaway there is that these rules are complicated. There are many components to them, and you need to be prepared to be able to respond to how you're complying with each and every aspect that applies to your operation. The second main bullet I have on this slide is be prepared to tell your story. These rules that have been implemented in accordance with the FSMA mandate are complicated. There's a great deal of flexibility within these rules because the rules are intended to apply to a very diverse animal food industry. And so there are nuances in terms of how a certain requirement may apply in one situation versus another situation. And so although we heard some good resources that are being made available through the Washington State Department of Agriculture earlier in this meeting about a checklist to focus different facilities on the individual requirements, generally these inspections, to my understanding, are very much conversation-based. You need to be able to explain how you're complying with different requirements and how those requirements are being addressed within your certain situation, within your food safety plan, if that requirement applies to you. There is a general compliance expectation that local management will be able to explain the facility's food safety plan and how its contents were determined. It's already been mentioned during the meeting today that if you are required to develop and implement a written food safety plan, that plan needs to be developed and overseen by a preventive controls qualified individual. We talked a little bit about the training that goes into becoming recognized as a qualified or preventive controls qualified individual as well. Under the requirement, under the 507 CGMP and preventive control requirements, that PCQI is not required to be an actual employee of the facility. And so I'm aware that there may be instances among animal food facilities where a facility could theoretically hire a PCQI to come in and help them develop and implement and oversee their program. I think the takeaway in what I'm trying to say here is that if that is your case, there still is a general expectation when an investigator arrives at the facility that the facility itself will be able to explain the plan and how it works. If you do rely on a PCQI from an external source to develop and oversee your program, there's still a need for you as a local operator to be able to also demonstrate how it's working as well. I've received a lot of feedback from animal food facilities that have experienced inspections about the types of information requests that are being asked when an investigator arrives at a facility. And so on this slide, I am recommending that facilities be prepared to respond to these types of requests for information that may not be expressly required by the regulations themselves. So for example, when an investigator arrives at a facility, they may request to see customer complaint files. They may request to see lists of top customers and suppliers. They may request to see business volume information, organizational charts, table of contents for quality assurance manuals, things of this nature that are not expressly required to be provided by regulations. So think ahead about how you want to respond to these requests. Some industry facilities are comfortable in sharing information. Others are not so comfortable. And so just be aware that an investigator may pose these questions during an inspection. And it's a good idea to have thought that through ahead of time and how you want to choose to respond. We've had a number of discussions already today about the written food safety plan and how a key component of that is the hazard analysis. And so I would suggest that animal food facilities that need to comply with Subpart C of the preventive control requirements really need to be prepared to justify how they determine what hazards are known or reasonably foreseeable for their animal food and for their facility. One of the resources that's already been mentioned today is FDA's draft guidance for industry 245 for hazard analysis and risk-based preventive controls that has been issued by FDA. Appendix E of this draft guidance lists animal food safety hazards that have been associated with different types of animal food. If you've been in tune with draft guidance 245, and if you're aware of Appendix E, you may believe that there are some shortcomings associated with that list of animal food ingredients and the hazards that have been associated with the different types of animal foods. So I think it's yet to be seen if the FDA's final guidance for industry 245 will include Appendix E or not. But for the time being, if you're looking kind of as at a starting point, to try to identify these known and reasonably foreseeable hazards for your facility, Appendix E could serve as a resource to do so. In addition, I think FDA's recall information that they make publicly available is a good resource to look at when looking at the types of hazards that have been associated with animal food safety incidents in the past. So these are just two examples of resources, and there are likely many more that you can look at to help you determine and justify what types of known and reasonably foreseeable hazards are associated with your facility and your type of animal food. Next, I would really strongly suggest that you be prepared to justify the determinations that you make during your hazard analysis of these known and reasonably foreseeable hazards. Within the preamble of the Part 507 final rule for CGMP and preventive controls, and also FDA's guidance, they highlight certain hazards that have been identified as having the potential to cause serious adverse health consequences or death to humans or to animals. These are those SOCOTA hazards that have been previously mentioned during the meeting so far. And so certainly for those types of hazards, I think the general expectation from FDA and our state regulatory agencies is that there is a fairly high level of rigor associated with the controls that are in place to deal with those types of hazards if they are associated with your type of facility, your type of animal food. Now, I'm not suggesting that these types of hazards all necessitate the requirement to have a preventive control to deal with them, but the prerequisite programs that you choose to implement, if you don't use a preventive control, need to have a good level of rigor in order to be able to mitigate these hazards if they are known to be associated with your facility and your animal food. Just as a reminder, within the Subpart C 507 requirements, these are the 10 factors that are to be considered during the hazard evaluation when determining what the severity and the likelihood of occurrence could be for known or reasonably foreseeable hazards that are associated with your facility. And so as you look at the severity of those hazards, as you look at the likelihood of occurrence for those hazards, you need to be able to think through these 10 factors and formulate these factors into your overall decision as to whether these known or reasonably foreseeable hazards require the use of a preventive control or if they can be mitigated through the use of prerequisite programs. After you've conducted your hazard analysis, and in those cases where you've determined that a prerequisite program reduces the likelihood that the hazard will occur so that you don't need a preventive control, then you really need to be able to justify how that prerequisite program works, how it actually mitigates the hazard effectively, and to be able to demonstrate that. As has been mentioned already during other speakers' presentations, if you reference an SOP within your hazard analysis as the means to reduce the likelihood that a hazard will occur, I think you can expect that the investigator, either from the FDA or for the state, to ask to see that SOP and to be able to review it, to understand how it works and how it mitigates the hazard and in fact does reduce the likelihood of its occurrence. If you choose to rely on a CGMP under Subpart B of Part 507 to reduce the likelihood, I think that's a little trickier situation. If you're familiar with Subpart B requirements, there is no record-keeping requirements associated with the CGMPs. Still, I think that you should be able to demonstrate, and there ought to be evidence within your facility that the CGMP is in place and it's working, even though there may not be a necessarily requirement to establish a record for that specific CGMP requirement or program that you're using to reduce the likelihood that the hazard will occur. Another area that I'd like to mention is I think firms need to be prepared to respond to investigator requests about last load hauled information for bulk conveyances. This relates to the distribution requirements under Part 507. It also ties into the sanitary transportation rule and also BSE prevention requirements that may apply to a given facility. Although there are no specific requirements within any of these rules about a firm knowing what the last load hauled on a bulk conveyance was, firms do need to take effective measures to make sure what was last hauled on the conveyance is not going to be a source of contamination for the animal food that's going to be subsequently hauled on the same conveyance. And so there is a need to have effective means in place to be able to demonstrate that. One way of doing that is to have last load hauled information about the transport vehicles that are being used to haul animal food. Another bullet here that I want to mention is last about FSMA inspections is be prepared to spend a significant amount of time with an investigator during a PC inspection. I am aware that PC inspections have lasted 4 to 5 days in certain instances. That's not always the case, but it has happened. I am aware that PC inspections have lasted longer than 5 days. And so firms need to be prepared to be able to handle that type of length of duration if an inspection does take place. Let me switch gears and talk a little bit about FDA inspections in general, how to be maybe prepared to undergo an FDA inspection if you've not already been through that process in the past. First of all, FSMA mandated that FDA conduct inspections at all registered food facilities at prescribed intervals that I've listed on this slide. Now, FDA does not have the budgetary resources, I don't believe, to carry out the mandate to inspect all registered food facilities in accordance with the schedule that FSMA outlines. But there are more inspections occurring, and these inspections are occurring at facilities that have not underwent inspections in the past. So I think it's a good idea to have to understand what your rights and your obligations are if you do experience an FDA inspection. First of all, FDA has broad inspection authority to really inspect any factory, warehouse, establishment, any vehicle, reasonable times and within a reasonable manner. And they have the right to look at all pertinent equipment, materials, containers, and labeling associated with the food in the facility. There's no warrant necessary for an inspection. So if a facility is open for business, it's open for inspection. As has been mentioned previously, FDA is using what I would call a kind of a comprehensive inspectional approach now. When they visit a single facility, they're taking advantage of that time to look at all different types of compliance areas that facility may be subject to. And so what I've listed on this slide is some other compliance areas, in addition to the FSMA rules, that you may experience an inspection for. Medicated feed CGMPs have already been mentioned, the veterinary feed directive, BSC prevention requirements, things of that nature. So let me talk a little bit about the inspection process to begin with. When an investigator arrives, I think it's appropriate for a firm to ask for credentials. The investigator should be able to provide identification. The investigator likely will provide a notice of inspection, a Form 483, and if they don't offer that up, it's often helpful to ask why the inspection is being conducted and to get a sense of what the investigator wants to look at. I think it's reasonable for facilities to inspect investigators to comply with all applicable personnel safety requirements that are in place at the facility. I think FDA investigators are well trained on the need to do so and probably well positioned to follow through on the safety requirements that you may have in place. It's my recommendation that a designated employee at the facility should be present for the inspection and really be there to kind of handle the investigator's requests that may occur throughout the inspection. The designated employee would accompany the investigator, would know the rights and obligations that the facility needs to comply with. The designated employee should provide answers to questions to the investigator, always providing truthful information. Also be in a position to remedy issues or conditions if raised by the investigator during the inspection immediately, if possible, and if warranted. Typically, inspections begin with a tour. So it's good for the firm to kind of have a tour route planned for in advance. The investigator has the right to really see any part of the facility, but if your facility has some hygienic concerns, it may be a good idea to have a tour route planned so that those hygienic protocols can be maintained and your tour doesn't come into conflict with those criteria. Regarding samples, FDA has the ability to take samples. If they're taken, I would suggest that a split sample be obtained from the same lot. If a sample is taken, I think it's appropriate to ask the investigator what the sample will be tested for and the expected timing of the results, and then have a plan on what to do with this sample lot. For example, are you going to hold that lot till the results come back, or what are you going to do with that lot that's been sampled for investigative purposes? Taking pictures is a topic that comes up often. It's a complicated issue. Industry generally contends that the authority for FDAs to take pictures is not well established. I think FDA's view is contrary to that. But if the facility's inspection policy chooses not to allow pictures to be taken, I think the investigator likely will assert that FDA has authority to take the photos, and you're going to need to be able to respond in a manner to that response. If the facility's inspection policy does allow it, I think it's advisable to take the same types of pictures that the investigator takes for your own purposes. Regarding employee interviews, FDA's authority does not expressly provide for employee interviews, but if your facility inspection policy does allow that, I think it's a good idea for the designated employee to be present to correct any potential inaccuracies that may be provided during an employee's interview. FDA does not have authority to disrupt a facility's normal operations. What I mean by that is if you're operating a piece of equipment An FDA investigator does not have authority to tell the facility to shut down the equipment, disassemble it so they can look inside. But in the same respect, if you're performing normal maintenance on that facility and have it open, they have every right to inspect it. So just be aware of those types of situations. Last on this slide, I would highlight that if you receive a questionable request during inspections, I think it is acceptable to ask the investigator to put the request in writing and ask the basis for why the information is needed so that you can have further discussions with your management or your legal counsel to review the request. I think that that's a way to maybe sort through requests that you may believe are questionable that may occur during the inspection. Let me switch gears and talk about post-inspection experiences. As has already been mentioned, investigators will typically conduct an inspection exit interview with facility management. A form FDA 483 is used to document inspectional observations. These are typically alleged violations or objectionable conditions that the investigator notices during the inspection. The facility management should provide any basis they have for disagreeing with the inspectional findings with the investigator during this interview so that the investigator can document that. Investigators will often ask management to sign an affidavit or declaration during the exit interview. Facilities are not mandated to sign the affidavit or the declaration, so I think it's a good idea to have a policy in place on how to respond to these type of signature requests. If a Form 83 is issued that would list alleged objectionable conditions, it may be beneficial for the facility to formally respond to FDA about these conditions before receiving further correspondence from FDA. Current FDA policy provides for 15 days for a firm to provide such a response if the facility wishes for the agency to consider what types of actions the facility may take prior to FDA determining whether additional enforcement action will be taken. So I would suggest that that's something that firms need to consider doing. If FDA believes it's warranted, they will issue a facility an untitled or warning letter based on the 483 observations. And these letters would outline the conditions that FDA finds objectionable and ask facilities to respond on how they're going to correct these observations. My advice is to always provide a response to such letters in a timely manner. If more time is needed, inform FDA of that. When responding, be sure to note the observation and how you're going to address the condition. I think it's advisable to consult legal counsel when responding to an untitled warning letter as well. Always follow through on any corrective actions that you commit to within the response letter. Depending upon the significance of the non-compliant condition, FDA does have a number of enforcement remedies they can use to correct the situation. So as an industry, we need to take these conditions seriously and respond appropriately. I wanted to highlight that the FDA inspection guidance that the NGFA has made available that kind of outlines rights and obligations for our industry. This document is publicly available on the NGFA website if participants during this webinar are interested. Last, I just want to briefly mention the FSPCA that's been talked about already. It's an alliance that was formed back in 2011 to really develop training and educational materials to help the industry comply with regulations promulgated under the Food Safety Preventive Controls Alliance. There are specific animal food training materials that have been developed. This is a screenshot of the FSPCA website. I would encourage you to visit it if you've not already. One of the main training materials that has been developed through the FSPCA is the standardized curriculum recognized by FDA as being adequate for training purposes for an individual to become a PCQI. There are a number of delivery vehicles for this course. There are in-person courses, virtual courses, blended courses. It is a rigorous course, about 20 hours in length. There have been a number of of individuals from our industry that have completed the course. This is a slide that just illustrates the number of PCQI certificates that the FSPCA has issued, almost 10,000 to date since the course was rolled out in June of 2016. There's also a CGMP for animal food online FSPCA course that has been developed. This is a standalone course from the standardized curriculum, but I wanted to mention that it's been developed and available as well. So again, I appreciate the opportunity to share some perspectives, and I know I'm short on time here, so maybe ran a little bit over, so I apologize for that.
Not at all. No apologies. Thank you so much, Mr. Fairfield. We really appreciate hearing the perspectives from industry and your insights into how firms can prepare for a FSMA inspection and the best practices for interacting with the inspectors. I think we have time for a couple of questions, and I see in the chat box we have, let's see, when is FSMA enactment determined to be?
Well, FSMA was signed into law in 2011.
Right.
Compliance dates established for the major rules that we are talking about during this workshop, and the compliance dates for these major rules have all come and gone. So businesses of all sizes are expected to be in compliance with the requirements that apply to their operations at this point in time.
Right, right. Okay. Any other questions from our participants? And thank goodness we're going to have copies of your presentation so that we can refer back to all your good practices and insights.